Title 13, Compromises and Arbitrations, Chapter 1, Compromises, 2028. A compromise is a contract whereby the parties, by making reciprocal concessions, avoid a litigation or put an end to one already commenced. 2029. The court shall endeavor to persuade the litigants in a civil case to agree upon some fair compromise. 2030. Every civil action or proceeding shall be suspended, 1. If willingness to discuss a possible compromise is expressed by one or both parties, or 2. If it appears that one of the parties before the commencement of action or proceeding offered to discuss a possible compromise, but the other party refused the offer. The duration and terms of the suspension of the civil action or proceeding and similar matters shall be governed by such provisions of the rules of court as the Supreme Court shall promulgate. Said rules of court shall likewise provide for the appointment and duties of amicable compounders. 2031. The courts may mitigate the damages to be paid by the losing party who has shown a sincere desire for a compromise. 2032. The court's approval is necessary in compromises entered into by guardians, parents, absentees, representatives, and administrators or executors of decedents' estates. 2033. Juridical persons may compromise only in the form and with the requisites which may be necessary to alienate their property. 2034. There may be a compromise upon the civil liability arising from an offense, but such compromise shall not extinguish the public action for the imposition of the legal penalty. 2035. No compromise upon the following questions shall be valid. 1. The civil status of persons. 2. The validity of a marriage or legal separation. 3. Any ground for legal support. 4. Future support. 5. The jurisdiction of courts. 6. Future legitim. 2036. A compromise comprises only those objects which are definitely stated therein, or which by necessary implication from its terms should be deemed to have been included in the same. A general renunciation of rights is understood to refer only to those that are connected with the dispute which was the subject of the compromise. 2037. A compromise has upon the parties the effect and authority of res judicata, but there shall be no execution except in compliance with the judicial compromise. 2038. A compromise in which there is mistake, fraud, violence, intimidation, undue influence, or falsity of documents is subject to the provisions of Article 1330 of this Code. However, one of the parties cannot set up a mistake of fact as against the other if the latter, by virtue of the compromise, has withdrawn from a litigation already commenced. 2039. When the parties compromise generally on all differences which they might have with each other, the discovery of documents referring to one or more but not to all of the questions settled shall not itself be a cause for annulment or rescission of the compromise, unless said documents have been concealed by one of the parties. But the compromise may be annulled or rescinded if it appears only to one thing to which one of the parties has no right, as shown by the newly discovered documents. 2040. If after a litigation has been decided by a final judgment, a compromise should be agreed upon, either or both parties being unaware of the existence of the final judgment, the compromise may be rescinded. Ignorance of a judgment, which may be revoked or set aside, is not a valid ground for attacking a compromise. 2041. If one of the parties fails or refuses to abide by the compromise, the other party may either enforce the compromise or regard it as rescinded and insist upon his original demand. Chapter 2. Arbitrations. 2042. The same persons who may enter into a compromise may submit their controversies to one or more arbitrators for decision. 2043. The provisions of the preceding chapter upon compromises shall also be applicable to arbitrations. 2044. Any stipulation that the arbitrator's award or decision shall be final is valid, without prejudice to Articles 2038, 2039, and 2040. 2045. Any clause giving one of the parties power to choose more arbitrators than the other is void and of no effect. 2046. The appointment of arbitrators and the procedure for arbitration shall be governed by the provisions of such rules of court as the Supreme Court shall promulgate.